A very warm welcome. You're joining us here at Hyde Park on Other Derana 24. Tonight we will be basing our discussion on the recently published UNHRC comprehensive report, the advanced unedited version of the comprehensive report of the Office of the United Nations High Commissioner for Human Rights following the UNHRC, the High Commissioner Volker Turk, his visit here in Sri Lanka in June. Now, ahead of the full report, this report suggests accountability mechanisms and other measures Sri Lanka should take in complying with UNHRC expectations of Sri Lanka in adhering to or in being accountable for alleged war crimes committed during the final stages of the war. I've invited to our studios an attorney at law who specializes in constitutional law, an author on UNHRC related resolutions going back to year 2012, post conflict here in Sri Lanka. And one of his reviews, his articles were published in the Groningen Journal of the International Law. Now, this is a prestigious peer-reviewed journal, a platform which remains a springboard to discuss matters as these, especially UNHRC-related war crimes, accountability-related discussions among international scholars. So let's talk about why this is important for Sri Lanka now and what Sri Lanka should do, whether to comply or whether to cooperate, or whether Sri Lanka should look within for an internal mechanism, and how Sri Lanka is going to work to address the external mechanisms that are expected from the Sri Lankan side. Let me warmly welcome to Hyde Park attorney at law and author Dharshan Weerasekera. A very warm welcome to you.
Thank you, Indeewari. Thank you for having me here.
Tell me about the Groningen Journal article. This was about Sri Lanka's accountability expectations, I believe.
Well, I have been working on these resolutions and their impact on Sri Lanka since 2012, and in about around 2020, I had drafted an article which I sent out to some international journals, but they had questions over it and we discussed. And after maybe 2 years of back and forth, this journal published this comprehensive article. It's about 60 pages, the only article published in an international journal on these resolutions specific to Sri Lanka. So it is now, some of these ideas that I had discussed are now being discussed by international scholars. Now, you started the discussion by mentioning the advanced unedited version of the report of the High Commissioner submitted or released to the public a few days ago. And that is the copy, advanced copy of a comprehensive report that the High Commissioner was requested last year in October at the UNHRC session. He was requested by a resolution 57-1 to file this September. So now he's filing that report. It's a much anticipated report because, as I mentioned and as you mentioned, it's comprehensive, supposed to be comprehensive. And people were looking forward to what he was going to say, first on the issues of human rights in Sri Lanka, and second, specifically on this external mechanism, evidence gathering mechanism that was established in 2021 on Sri Lanka by a resolution of the Human Rights Council, resolution 46-1. Sri Lanka's co-sponsored resolution 30/1 of October 2015, the famous co-sponsored resolution on which there's been so much controversy or back and forth. In 2020, when the Gotabaya Rajapaksa administration took over, soon afterwards, the government of Sri Lanka formally withdrew from that co-sponsorship of Resolution 30/1. Nevertheless, after 1 year, a group of nations led by the United Kingdom, Germany, and Canada reintroduced a resolution on Sri Lanka. That is Resolution 46/1, which was adopted in 2021. And that resolution, and by that resolution, the Council reasserted the conditions of, all of the conditions of Resolution 30/1, and they added one more. That was this external mechanism, which is...
what is this? So if you can explain to us what exactly this external mechanism is and how this applies to Sri Lanka. Does this pose a risk to Sri Lanka, or is this something that Sri Lanka, upon compliance, will get to address these concerns of the international community?
Thanks so much for that question, because no, the quick answer is it's a very, very controversial mechanism. It is not at all part of a regular process or procedure of the United Nations Human Rights Council. It's a controversial to begin with, because what this mechanism, and it's here I have the resolution 46/1, and it's important, I think, and thanks for this is for focusing attention on this matter, because lots of people in the Sri Lankan public and also the international audience, people don't know about this and what has happened. So it's a completely new device, and what it does is it authorizes the High Commissioner of Human Rights, his office, to establish a mechanism, and I'm quoting from this, to collect, consolidate, analyze, and preserve evidence and material. It says evidence and material, meaning even material that may not meet the standards of normal evidentiary standards.
What do you mean by normal evidence standards? What are these standards?
For example,
do you need standards to gather evidence?
Well, yes. For example, in a court of law, right, there are certain, we have an evidence ordinance, for example. There are certain things you cannot use, hearsay evidence. Somebody said something, such things.
So how does this not comply with the standard or normal way of collecting evidence?
Yeah. So the issue is that it says, this phrase says evidence and material. So any material regarding alleged abuses of human rights law, and it specifies human rights law and humanitarian law violations that have occurred in this country. Now, human rights is the general law that relates to human rights. Humanitarian law is the law that relates to armed conflict. So the allegations against us in terms of those humanitarian law violations are the ones that go back to 2009 with reports like the Darusman report, and the 2015 more key report called the OISL report, the Office of the Human Rights High Commissioner's investigation on Sri Lanka. So those are looked specifically at these humanitarian law violations. So this 46/1 mechanism is expected to collect evidence and material of those, and also it says here very specifically, search or explore ways of holding people accountable, that is Sri Lankan citizens, for such acts, including through universal jurisdiction action in foreign countries. Universal jurisdiction means where a foreign country can bring before their courts a citizen of a country, another country, if they're visiting that country or so. So this is a mechanism that's not just designed to collect evidence or material. It is designed to consolidate that material, make it into a single database of some kind, and analyze it, and then work with third parties, third countries, in filing legal action or taking measures against individuals, including Sri Lankan citizens, based on that material.
So are you saying this targets individuals?
Yes, I am saying that, and it is that this is what I'm saying. It is not. It doesn't seem, I argue, compatible with the mandate of the Human Rights Council, whether the Human Rights Council can devise or authorize something like that, because the Human Rights Council is governed by its charter. There's a charter. It's called United Nations General Assembly Resolution 6251. And that charter sets out the principles according to which this institution is to be governed. And one of those principles, paragraph 4, says explicitly, the council in its conduct shall, that's a mandatory requirement, shall be governed, amongst other things, by the principles of cooperation and constructive international dialogue. Constructive international dialogue. Now, the government of Sri Lanka, or successive governments of Sri Lanka, including the present one, have categorically rejected this mechanism. So, if the government of Sri Lanka rejects it, then by definition that would conflict with those requirements, cooperation and constructive international dialogue, especially if this mechanism contains material against Sri Lankans and it's used in order to arrest or try Sri Lankan citizens. So, as I said, on the face of it, this goes against, it seems to go against the mandate of the council. But nobody has taken up that issue. And over, this mechanism has been reaffirmed over these past 4 years. And last year, the importance of this conversation that we are having today in Indeewari is that last year, this mechanism came up for review. And in that resolution, the council says to the High Commissioner, okay, we'll extend your mandate by 1 more year, and in September of next year, provide us with a comprehensive report on its progress. In other words, okay, the comprehensive report is supposed to be on the human rights situation in Sri Lanka, but that includes this mechanism as well, because it was authorized by 46/1, and this is a process that extends the mandate of 46/1. Now, we have here, I think I showed you earlier,
the comprehensive report.
Exactly, the advanced copy.
The unedited version.
The unedited version. Unedited, they say that because they can always change a few words at the final. But this is that copy. Right. Now, does this look like a comprehensive report to you? This is 16 pages. 16 pages. And they have dedicated 2 pages. That is about 9 paragraphs, actually 8 paragraphs to this mechanism. To this mechanism. And it comes at page 12 and 13. So the hike, and this is where I have some serious problems or questions with this report, because as I said, the remainder of this report deals with human rights concerns and so on. But on the mechanism that I said,
this is the hybrid mechanisms that they're talking about, interventions.
Yeah, the external mechanism that we are talking about. And now that mechanism is called the Sri Lanka Accountability Project. If you get on the website of OHCHR, it will take you immediately to Sri Lanka Accountability Project. Now, if somebody, like the Human Council, requests the High Commissioner, OHCHR, to produce a comprehensive report, amongst other things, on the Sri Lanka Accountability Project, one expects a report that covers, first, its mandate, its legitimacy. 2, what it has been doing for the last 4 years. By the way, they have a budget of $4 million per year. So this is 4 years, $16 million funded through the general budget fund of the United Nations. So this is coming from New York, I think, the funds. So 16 million over 4 years. And the council has requested a comprehensive report on its progress. So as I said, generally it would start with its mandate to show that it's legitimate. Second, something of its work. What kind of evidence has it collected? Where are its sources?
You mean to come up with these conclusions?
Exactly.
Okay.
I mean a comprehensive report on anything. And third, what kind of actions has it taken? Has it collaborated with foreign countries in extending, using this material in order to pursue legal actions against people? And what are those instances? There is nothing here about that. It's very general statements. This says that we have collected 105 pieces of evidence. Well, where are they from? Do these pieces of evidence, some of these at least, come from sources associated with Sri Lanka's critics, NGOs and other sources? Now, in a previous report of the High Commission, and this is, I'd like to point this out, another comprehensive report. It's called 5420. In 2023, the High Commissioner explicitly states that this Sri Lanka Accountability Project started with the following. They took the database they had for the OISL report, that is their report. Then they took other materials that the UN had with them. To that they added, High Commissioner states in 5020, 9 NGOs and academic sources. It says in that record. It's on record. So at that time, when I was writing my article, and this is what was compelling to even some of the international scholars that looked at this, what are the identities of those 9 NGOs and academic sources that comprise the foundation of this database? Now, in Indeewari, I looked at this new, the unedited version. I read it very carefully. Nowhere in this 8 paragraphs on this mechanism is there any mention of these 9 NGOs and academic sources that, according to the High Commissioner's admission, form the basis of this database. Now, if even one of those NGOs happens to have been funded by some critics of Sri Lanka, then obviously it would taint this database. Any reasonable person would say, we need to know the identity, especially if one is accused under this. So, what are the identities? Now, in this new, that's why I looked at this very carefully.
So can Sri Lanka make a case here and request that these evidence-based, the collection of data or evidence to make it transparent? And I believe the UNHRC must comply, and they have to remain transparent with the other countries.
Yes, of course. That's the issue. Now, the government has rejected this mechanism. So, from the government's point of view, I don't speak for them, but as a reasonable person, I'm assuming from the government's point of view, once you reject something, you can't go back to that and keep asking questions. No, it's sort of indirectly then you legitimize something. So once you reject is reject. The issue is whether other countries take up this issue. Now, and here, this is why I'm thankful to you for having me here, because this is where the urgency of this matter comes. Now, as I was explaining, it seems arguably that this mechanism is contrary to the UNHRC's founding document, because it doesn't comply with cooperation or international constructive international dialogue. So there is that problem. There is also these problems with its possible contents. So these things. Now, there is a doctrine in international law that I'm sure you're familiar with. It's called the doctrine of acquiescence. Acquiescence. To acquiesce means if you don't protest against something, then it's taken as if you acquiesced. Now, this comprehensive report, High Commissioner was given 1 year. That means this is coming up for review almost in this September. If once this report is filed, now as I said, this report doesn't even mention really the Sri Lankan Accountability Project. It talks about other human rights violations. Government will reject the mechanism as always. But if other nations do not specifically, at least by one sentence, challenge this mechanism or question its legitimacy, there is a danger in the worry of this mechanism gaining legitimacy under this doctrine of acquiescence.
So do you say the Sri Lankan government hasn't done enough or taken this seriously to make a strong enough standpoint and to cooperate or coordinate internationally to make Sri Lanka's position clear. For a long time, Sri Lanka has maintained the importance of domestic mechanisms or reconciliation and accountability measures taken from Sri Lanka within the country. And you're saying this will lead to a dangerous situation. But let me just go back to the advanced unedited version. The summary of the document says the report looks at, it notes the new government's pledges to address long-standing issues, but highlights the need for a coherent plan and concrete steps, particularly regarding accountability for past human rights violations and international crimes. The report provides recommendations for the government, the international community, to advance accountability, reconciliation, and human rights. It's very clear that this is in line with the government's efforts to cooperate with the UNHRC. So how is this going to really be such a risk to Sri Lanka? Are you saying there is no genuine intention for accountability, or is this an encroachment of Sri Lanka's sovereignty?
It is, and that's exactly what the public needs to be aware of. There are two issues here. There is the issue related to the Sri Lankan government's continuing engagement with the Human Rights Council and the international community regarding concerns that the international community, Human Rights Council, have rightly expressed about, one, things that may or may not have happened during the conflict with the LTTE. The second is ongoing concerns about the state of human rights in this country. Those are two different issues. Now, regarding the things that may have happened during the war, you have things like this external mechanism that the Human Rights Council has established. And I'm saying there are legitimate concerns over its legality and its possible contents. Then there are the issues on which the government is continuously engaged with the international community. So yes, when this document, this report of the High Commissioner contains continuing allegations about human rights. So those the government will obviously engage with, and they will continue. The problem is that the government will, in my view, they will simply reject this mechanism. But if other nations also express their concerns about the general human rights situation in Sri Lanka, but do not express their concern specifically about this mechanism, in this whole debate, the mechanism gets pushed under the rug, as it were. And if that happens, then this gains legitimacy, in which case it becomes a precedent. And
precedent for other countries
exactly.
In conflict,
not
post-conflict?
Even post-conflict, because this is, as I said, any time a government rejects a mechanism, and that mechanism continues to operate, then by definition, that mechanism is an encroachment on the sovereignty of such country. So all countries would have to be concerned if this thing is a precedent.
So this is not just in the interest of Sri Lanka, you mean?
Exactly.
Any other country could see international interference if Sri Lanka allows this to go through. Is that, I'm trying to summarize it.
Yes. No, if any other country would have to be concerned if this mechanism gains legitimacy, and therefore it's in the interest, not just of Sri Lanka, but other countries, to express concern. We can have a discussion, but express concern at these upcoming sessions, but specifically on this mechanism. It could be a sentence, but simply, where is the legitimacy in terms, has the High Commissioner explained the legal basis of this, the mandate? Has the High Commissioner explained questions over the sources of these evidence? Because the High Commissioner in his previous report has said there are 9 NGOs. Well, what are those NGOs? Those are legitimate concerns. So if even one other nation raises those questions or does not raise, then what I'm saying is there's a danger that this becomes precedent. But if they do raise, then they protect their own interests. So that's basically what I'm saying.
We're talking about weaponizing human rights.
Exactly.
Internationally. What is the risk here for Sri Lanka? While it is understandable that Sri Lanka must cooperate with the international community, Sri Lanka must comply with international law, what is really the risk here for a small country like Sri Lanka, which goes back and forth from accepting, denying, and then co-sponsoring, once again rejecting, and now complying? So what kind of a precedent do we as a country in post-conflict scenario alleged of war crimes set to other nations?
Yes, that's a really good question. Now, the basic principle that I operate from is that no one is above the law. That's the basic principle. So in international law, that should apply to the UN as well. The UN is an organization under the law, and that means it's under or subject to the UN Charter. Now, as you rightly point out, all members of the United Nations have obligations under that charter, and they must meet it. So if they're fighting terrorism, for example, they have to meet, they must comply with the relevant provisions of international human rights law, international refugee law, and international humanitarian law. That's obvious. But what people don't mention is that the United Nations organization itself has reciprocal obligations towards the members when it is investigating them or when it is taking action against them. Now, my position, and I hope it's not unreasonable, is to say there is a citizen of Sri Lanka, and in fact the people of Sri Lanka have a right to insist that the UN follow the law. And if there is indication that perhaps it hasn't, we have to look into it. So I am not saying the UN cannot or UNHRC cannot look into Sri Lanka's human rights record or humanitarian law record, but it must do so according to the law, according to within the four corners of the law. And that is an issue that would be relevant for all nations, whether you're talking about Sri Lanka or some other country. They would also say, yes, it's in all our interest to have a UN that is consistent, that is credible. The problem today is that the UN is becoming less and less credible. It is being criticized of double standards, of this, of that, of favoring various parties. So when you have an instance such as, say, this external mechanism, where the High Commissioner has gone on record saying we used 9 databases, but on the final report we have no word on it. When we have instances like this, it increases suspicion of this organization, and it's in everybody's interest to make sure that the UN or UNHRC, Human Rights Council, follow the law.
We'll take a short break. We are in conversation with attorney at law Dharshan Weerasekera, an author and lawyer who specializes in constitutional law on the UNHRC matters and resolutions. He's talking about the risks of setting a precedent if Sri Lanka accepts an external mechanism, and what post-conflict justice risks other countries will face globally, and how we understand the situation in terms of accountability. We'll come back after this short break. You're joining us at Hyde Park on Other Derana 24. Welcome back. You're joining us at Hyde Park on Other Derana 24. We are in conversation with the author, attorney at law Dharshan Weerasekera, who writes about international human rights law, UNHRC, sovereignty and accountability related to international mechanisms. We were talking about Sri Lanka's case in relation to the UNHRC advanced report, the unedited report based on the visit of UN Human Rights High Commissioner Volker Turk to Colombo and other parts of Sri Lanka in June this year. Now, we were talking about a domestic mechanism. Sri Lanka's standpoint throughout since 2012 to maintain a domestic mechanism. But if domestic courts are the only avenue for justice in cases as these, where there are allegations of human rights violations and accountability questions during the final stages of the war here, how can we build trust among not just the people, but victims of both sides, those who are concerned, those who want Sri Lanka to address past mistakes or alleged violations? So how can we just rely on domestic mechanisms if the call is bigger than just sorting it out locally?
Yes, thank you, Indeewari. Now, the question is based on the criticism that the domestic mechanisms are inadequate. This is a criticism that the international community has made, and critics of Sri Lanka, that the domestic mechanisms are politicized. First of all, what do we mean? What is meant by domestic mechanisms? There are two very main ones. That is the Lessons Learned and Reconciliation Commission, LLRC for short, and the Paranagama Commission. LLRC came out in November 2011. Paranagama Commission report, there were two mandates, but the second one came out in 2015, late 2015. Okay, so those are the two mechanisms. These are vast, extensive reports. Now, the criticism, and actually it's repeated in every one of these reports of the High Commissioner. So even in this present one, which is the one that I had before, they start out with the statement that, here we go, because this is very important, this is very important. In the absence of progress towards accountability by domestic mechanisms, and in accordance with Human Rights Council resolution, in the absence of progress. Now the issue here is...
Which means LLRC and the Paranagama Commission, they failed to deliver justice. So my question again, in the face of such failure domestically, why should the international community believe that Sri Lanka will fulfill these accountability commitments?
Yeah, that's the question. But what is the evidence that they failed? That's my question. In other words, anybody can accuse a domestic mechanism of being politicized. Anybody can do that? No. In the same way that a person could accuse the UN report to be politicized or biased. But if the UN is to accuse a domestic mechanism of a country, UNHRC, they have to produce some report that argues that shows, they can't just claim it. Now, because there is a principle in international law that says domestic remedies must be exhausted before resort to international ones. So if they are going to go to international ones, it's their obligation. Like I said, this is a reciprocal obligation. The reciprocal obligation. They must produce some report that shows or indicates that how the LLRC report, for example, is biased. There is no such report in Indeewari. There is no such report on the Paranagama. Now I want to tell you something personal about this. On the LLRC, I was junior in 2012 odd to C.R. De Silva, PC, who was the chairman of the LLRC. I asked him this question. I asked him, how do you respond? Because at that time, when this report came out, the accusations were that the commission was biased. It was and his reply remains with me today. He said, I cannot reply to that criticism, except I have asked my office to make public our entire record. Therefore, Indeewari, and I can attest to this, at that time, this database now has been removed, but there was a database called the Lessons Learned and Reconciliation Database. I hope it's not lost. It must be somewhere. Now, and they put all of their evidence into it, so that anybody who questions it, or who wants to criticize it can look at it and show where the LLRC has been biased or has been partial. Now, nobody did that. So beyond that, I don't know what a domestic mechanism can do to show that they have, obviously at that level, one can't find commissioners or commissioners who haven't worked for the government. It's unreasonable. Any commission in any country that people appoint, those people have at some point in their lives worked at high levels in that government. Just because they have done so does not mean their work is biased. You have to look at the product and then argue that it is biased. To this day, to the best of my knowledge, there is no UNHRC or any other that has said the LLRC Commission's conclusions cannot be sustained or unreasonable. There is no objective assessment of Parnagama Commission's reports, conclusions, to say they are unreasonable. Therefore, the Sri Lankan people have a right to rely on the conclusions of those mechanisms rather than conclusions of UNHRC. Now, the other side is also the case. If the UNHRC is saying the domestic mechanisms are biased, then we ought to be able to look at the UNHRC's products to see how good they are. Now, I did a small assessment of this OISL report in 2018. It's been published. And part of it was sent as material to this paper also, this academic paper. And you know, the evidence in this report is very weak. They are saying, for example, that Sri Lankan armed forces, okay, one of they say that Sri Lankan armed forces bombed or shelled hospitals. In one page, I can show you the paragraphs. In one place, they say, we have no evidence that LTT gun positions may have been or were positioned inside buildings that used to be hospitals or close to hospitals. They say that. Another page, the next page, they say, we have evidence. We have such and such a person's statement that LTT gun positions were stationed close to buildings that used to be hospitals. So, if there are contradictions that of such a nature, they say, for example, another charge that Sri Lankan government deprived these people in the conflict zone of humanitarian aid, that means food and medicine. There are recorded like reports, including testimony from the UN resident coordinator, that supplies sent by the government were very impressive. There was a commission, I mean there was a group called the Consultative Commission on Humanitarian Assistance. And the resident coordinator was part of that, the group. He knew what was going. So these statements are there. So when you have these kinds of things, how can a report say the people in these regions were deprived of humanitarian assistance? My point is this. A person could make the same claim that the High Commissioner, for example, makes against the Sri Lanka's domestic mechanisms against the UN report. In the same way now, at least the OISL report is published. We can look at it. Now this Sri Lanka Accountability Project, we don't know what's in it. And this is the danger. We don't know what's in it.
Right.
All right. So my point is that yes, we have every right to rely on the domestic mechanisms. And I have said that, I have said all along, that if there is to be a genuine reconciliation project, let's look at these reports. Let's take them seriously without dismissing them, and then build on that.
In September, the UNHRC sessions will convene, and are you saying if Sri Lanka has to make a standpoint to start now, to start working on this now? Is that what you're saying?
Yes, I'm saying not only Sri Lankan government, because government will probably do what it's been doing for the last, in other words, reject this mechanism and go from there. But I'm saying civil society organizations, groups, ought from now on to interact or engage with international organizations in order to bring this issue to the front.
The idea of a separate state, is really the discussion also internationally. We saw in the UK and Canada the Tamil diaspora calling for a separate Tamil state. Recently, a monument, Tamil genocide monument, was unveiled in Canada. Sri Lanka maintained that the LTTE, a proscribed organization, a terrorist group, how the government could allow, the Canadian government, to allow such a symbolic narrative be spread there. But what is really the risk here for a sovereign state, the sovereignty of the state? For a long time, there's been narrative about threats to Sri Lanka's territorial integrity. But outside the country, internationally, do you think Sri Lanka has done enough to work with allies and other states like Canada and the UK, where a proscribed organization is able to lobby and move forward with what they believe is their goal?
Yeah. No, the simple answer is no, and it's a sad situation, and I'll explain why very quickly, and I can connect this Sri Lanka accountability project and the alleged evidence or material it is collecting, and how that can be used in order to sustain or support a claim for an international endorsement of self-determination for Tamils in this country by interested parties. So, this is the danger. The danger is, well, first of all, self-determination. That means a claim of a right to independence. So, now there is a right, an accepted right to self-determination under international law. People have that right under international law.
So you can lobby for it,
yeah,
and you can fight for it,
you can
and
fight
at an
for
international court?
Yes, you can fight for it. Now, for example, but you have to show that there are certain conditions. Because now in every country, Indeewari, there are ethnic groups, there is a majority usually, and there are minorities. Now, if every minority in every country starts saying, we want a separate state, there won't be any countries. It's so fractious. It'll fracture every country.
What are these conditions?
Right. So so people have now devised certain conditions.
These are conditions set out by the UNHRC mechanism.
Not really. No.
Under international law.
International law.
Right,
exactly. And there's a very interesting and important Canadian case. It's called Reference RE Secession of Quebec. As I think it's 1998 or so. And the Canadian Supreme Court, which is a prestigious court, discussed this issue because in the 1990s there was a drive in the province of Quebec for secession from the rest of Canada. And this became a very acute problem. So the Prime Minister of Canada requested the Supreme Court of Canada to provide an advisory opinion on whether the Quebecois or Quebec people could secede. And the court looked at this and issued a very famous judgment. So they asked, the Prime Minister asked, or I think the questions were whether the Quebec province could secede under Canadian law and also international law. So the court answered no to both those questions. The first question, because Canada is a federal state, and the court said a province that has joined a federation cannot unilaterally leave it, withdraw from it, without the consent or without the concurrence of the other members. So that's under Canadian law. Then they looked into the international question. Is there a right of Quebec people for a unilateral declaration of independence? So the court looked at that concern. If that is granted, then anywhere, even like Tamils living in Canada today, in 20 years, 25 years, could say, well, this is our traditional homeland, wherever they are, and say we want independence. That would be wrong, be difficult, unreasonable. So, so the court didn't look at the Tamil question, but the Quebec question, and said, well, at the minimum, there have to be 3 conditions. to declare independence or to ask for self-determination. The first question is, requirement is that the people demanding this must be under formal colonial occupation. So Quebec doesn't qualify under that, and neither would the Tamils in this country. But the second requirement is that that people must be under alien domination and oppression, something to it. Alien domination and oppression. And the court went on to say, and there could be a third possible. And the third possible is that the people in question must be deprived of all chances at democratic participation. That means that they don't have a vote, they don't have a way of sending any representations, representatives to the parliament, and so on and so forth. Okay, so the Quebec didn't qualify under the second question either, because they couldn't really show that they are under alien domination or oppression.
Right.
And under the third also, because there are Quebec people in the federal parliament. So by definition, they couldn't qualify. Therefore, they couldn't. Now, now I'm turning to the Tamil issue. If there are powerful groups in other countries and they're advocating for this, not just theorizing, advocating, organized, advocating for a right to self-determination for Tamils in Sri Lanka, and there was a UN authorized or legitimized mechanism, the Sri Lanka Accountability Project, with supposed evidence of mass violations against Tamils, and especially on the humanitarian law issues, if they're looking at crimes against humanity, which mean crimes committed against an entire group of people, that suggests that the war was a campaign against the entire Tamil people as a whole, rather than just the LTT organization. If an international mechanism, database, with the legal imprimatur of the UN contains such evidence, then I think, or wouldn't you say, that the second condition, alien domination and oppression, remember there are three conditions, no? The first is colonial occupation, doesn't qualify. Tamils won't qualify. But that second, they might be able to make a claim under that second condition. So this is the danger. There's another case, the Kosovo case, International Court of Justice. We have no time to go into that.
Yes, we really
But my point is that the danger here, the connection is, if there's evidence like this, that it can be used in order to underpin an international drive by interested parties to gain such an endorsement. And it is in the interest of Sri Lankans today and also governments in order to address this now rather than wait for these things to happen.
Finally, I'd like to ask you now, you mentioned the Quebec ruling which emphasized that secession must follow a legal democratic process and negotiation, require negotiation, not unilateral action. So can Sri Lanka use this international process to counter diaspora argument, or in a more democratic sense really have discussions with the diaspora community? And what kind of a threat do we see here if Sri Lanka don't act now? You said under a third or second clause, Sri Lanka might face risk. But in moving into this situation with genuine intention to address concerns of accountability and allegations of human rights violations, as we spoke at the beginning, how should Sri Lanka really address this situation now? There is the Tamil diaspora working with international community. There's Sri Lanka here facing international resolutions and facing UNHRC sessions to face the international community. So how should Sri Lanka really balance this from a legal standpoint? We don't have much time, but if you can address that now.
Yes. Well, the first thing is, I think the Sri Lanka should insist that the UNHRC or whoever international person is doing this must follow the law themselves. They have to be consistent. Second is the Sri Lankans must insist on the domestic mechanisms and that principle that domestic mechanisms must be relied on first, exhausted before resort to international ones. Now, if the other side, if other people come and say, yeah, but we can't, your domestic mechanisms are biased, Sri Lankans cannot simply say, oh, okay, oh, they must be biased. They must question that to say, okay, well, show us how they're biased. That hasn't been done. And then also say, okay, so what about your reports? Let us look at those. Because they have to be unbiased too. Insist on that. Second is, now I'll finish with that. Now, Indeewari, we have now this war finished 15 years ago now. And there has been a lot of work done on the ground towards improving the standards of life of people in the north and the east. I was in the east. I had never been there. People who worked with me say, during the war or before that, when they went to school, they had to take a boat, apparently. Like Trincomalee has a big harbor. They didn't have a bridge over it or over large portions of it. So these students had to take boats. And when rough water, when the boat goes on the other side, they fall into the water. It was that bad. After the war, the government has built bridges, has built roads. You can go from Trinco to Batticaloa now in 2 hours. I'm told it took 13 hours to get there. So these things have been done, and Sri Lankans and Sri Lankan government has to emphasize this aspect, because that's also human rights. That is human rights. That's the essence of human rights. They have to emphasize those elements also and look at this human rights issue in a broader context. That's my point.
Right. Thank you very much, Dharshan, for your time here at Hyde Park. I believe we delve into a topic that we may have been talking in the future, closer to September, but you're really preparing Sri Lanka to address any concerns or risks way ahead of time. Thank you for your comments here at Hyde Park.
Thank you.
We were in conversation with attorney at law and author Dharshan Weerasekera, whose articles, whose publications have been featured in the Groningen Journal of International Law, a prestigious peer-reviewed journal, a platform again where scholars discuss matters as these. And Dharshan has been writing on UNHRC resolutions, international law, doing a lot of research on sovereignty and other cases where conflict and the UNHRC has worked hand in hand related to post-conflict mechanisms. We'll be back with yet another discussion at Hyde Park next week at the same time. Have a pleasant evening. Good night. I just have to edit my last question.